I'll now begin by the questioning by recognizing myself for 5 minutes. Mr. Whalen, the President has a constitutional obligation to, quote, take care that the laws are faithfully executed, quote. And he swears an oath to faithfully execute his office. Do these constitutional obligations in your mind require that decisions not to defend a law must be based on sincere legal analysis rather than a political calculation?
Absolutely. And further, they require that legal analysis not only be sincere, but be very carefully considered and responsible. Again, the point I would emphasize here is that putting aside questions of constitutional authority, the very basis on which Attorney General Holder has attempted to defend this action, the notion that is that this is consistent with the standard of defending any time there are reasonable arguments to be offered. And in fact, it's clear that that's not the case here.
So I guess the follow-up question is, do you believe the President's actions meet the Constitution's faithfulness standard?
No, I don't.
Right. Do you view the administration's actions in the DOMA litigation as an improper politicization of the Justice Department?
I do, and again, as I've outlined and detailed more extensively in my written testimony, I think we see a whole track record of undermining this litigation as well as the Don't Ask, Don't Tell litigation, which I've addressed in separate writings.
Ms. Gallagher, virtually every known society, as you mentioned in your testimony, since the beginning of history, has had some form of marriage. There have been some cultural differences in the meaning of marriage among various societies, but what elements of marriage have been universal?
Would you forgive me if I just made a brief remark on the politicization thing and then answer your question?
Certainly.
Thank you. For me, the context of this last decision to refuse to defend DOMA, you have to look at the history of this. When DOMA was first challenged in the First Circuit, a career Justice Department lawyer submitted a brief in that case, similar to the briefs that had won in other litigations. There was a huge outcry from an important member of President Obama's political base. That brief was publicly withdrawn, and then a new brief repudiating the purposes of DOMA was resubmitted. And so I just wanted to add that in addition to, when you're evaluating President Obama's Justice Department's decision now on whether it's politicization, I think you have to see it in the context of the very public way in which the Justice Department's actions were publicly politicized. Its legal strategies were shifted in response to politically expressed outrage. And now I'll let lawyers handle those questions. There's a basic shape to marriage in virtually every known human society, and it varies a lot. It's not unchanging, but it's always a public union, not just a private, personal, and intimate union. It's a sexual union. It's not some other kind of union, in which the rights and responsibility between a man and a woman, or I should say at least one man and one woman, because polygamy is frankly fairly common, especially in small tribal societies, in which the rights and the responsibilities of the man and the woman towards each other and towards the children their sexual unions naturally produce are publicly defined and supported, which means we don't just leave it up to a bunch of adolescents in the middle of their psychological dramas to figure out on their own what this whole big dimension of human experience means. Virtually every society has recognized you need a public institution that is dedicated to the idea that children need a father as well as a mother, and that brings the two sexes together into a union that protects the children that their bodies make together.
So do you agree or disagree with the Massachusetts Supreme Court's holding that government creates marriage?
The very worst part of the Goodrich decision is the one line, well, there's a lot of parts I don't disagree with, but it's the line that essentially that what we have here is a licensing scheme, right? As if the legislature of Massachusetts just sat around and dreamed up this idea called marriage. I think that government has a role in recognizing marriage because it's so important to the common good, but I do not believe that government invented marriage and has a right to redefine it, a moral right.
Well, thank you, Ms. Gallagher. I guess I'm about to lose my time here, so I'll now recognize Mr. Nadler.
Thank you, Ms. Gallagher. How would you explain to children like McKinley and Brianna, who are here with us with their parents today, that their family is not deserving and should be excluded from the protections and benefits of marriage, including the important confirmation the federal government considers them a family? Or do you consider these children expendable?
I think no children is expendable. And by the way, this is a question that's been answered about the ideal of marriage. It's not just, gay people have families that are not marital families, but they are families. I myself was an unwed mother, so I have firsthand experience with being in a family that's not a marital family. I don't think that you need to have a message of stigmatization and exclusion to protect an ideal which is important to the whole society.
That's the whole point of DOMA, to stigmatize and exclude.
Well, that is your opinion, with all due respect. It is not my opinion, nor I think what was expressed
How does excluding these people,
how does excluding,
by President, excuse me, I have the time. How does excluding these people help protect marriage?
Well, the way that I think the majority of Americans who disagree with you understand it is that these are not marriages, so it does not.
I didn't ask that question.
Because
I asked how does excluding these people from marriage help protect heterosexual marriages?
Because including same-sex unions as marriages denies at a public level that marriage is about, in an important way, bringing together mothers and fathers for children.
Now
secondarily, it is based on the idea that it is immoral and abhorrent to have a special.
All right. So in other words, we need to exclude.
Dedicated to bringing.
In other words, excuse me. In other words, we need to exclude people
to answer the question.
Yes, but you're answering it at length greater. I only have 5 minutes.
Okay, I apologize.
Now, you spoke exhaustively about a supposed politicization of the Justice Department under this administration. Your organization, which is based in New Jersey, spent nearly $650,000 on a campaign to unseat Iowa Supreme Court justices because of their decision that gay and lesbian couples should be able to marry in Iowa. Do you think that judges should decide cases, based on political concerns or they fear for their jobs? And if so, how does the judicial branch differ from the legislative branch, and what is the purpose of the Equal Protection Clause?
The National Organization for Marriage is a political advocacy organization, so I think it's appropriate for us to be politically involved in a way that the Department of Justice is not supposed to be politicized.
No, but are judges supposed to decide cases on the basis?
There's an argument about whether judicial elections are a good idea, but what I don't think you can say to the people of Iowa is you have an election for judges, but you're not allowed to vote no because you disagree with their decision on.
So you think judges should be in a position where they have to take into account the popularity, not just the justice of what they're about to decide?
Well, I think there's an argument about whether judicial elections are a good idea, and I have not expressed. I don't actually have an informed opinion on that.
Okay, thank you.
But
Professor Ball.
Thank you.
Professor Ball.
No.
Professor Ball, would you comment on Mr. Whalen's comments on the lack of any legal justification for the Department of Justice's decision on defending Section 3 of DOMA?
Yeah, I completely disagree.
Can you turn on the mic, please?
It is on. Sorry, it's probably not close to enough to my mouth. I completely disagree with that characterization. It seems to me that the Obama administration has done a careful and thorough job looking at the arguments in favor of DOMA. And they have decided that, in fact, there is no rational reason to deny couples who are already married under their state laws the hundreds and hundreds of federal benefits that are based on marriage. It's important in understanding the Obama administration's decision that marriage, family law, domestic relations has always been a matter of state jurisdiction. So in that context, I think the Obama administration's decision here is the correct one.
Thank you. And finally, what is your response to Mr. Whalen's claims that all 11 federal circuits to have addressed the question have determined that rational basis review is the proper basis to apply to laws that discriminate against gay men and lesbians?
Well, I can see that in the 1980s and 1990s, there were a handful of circuit courts that, relying on Bowers versus Hardwick, which is no longer good law, did conclude.
No longer good law because it was explicitly overruled by the Supreme Court.
Exactly correct. They did conclude that lesbians and gay men's sexual orientation classifications were not entitled to heightened scrutiny. What has happened, of course, as you mentioned, is that case has been overturned. And what we've had in the last few years is some circuits citing to those old cases whose legal reasoning is no longer valid without engaging in the appropriate analysis of whether a particular classification merits heightened scrutiny. So I disagree with that legal conclusion.
And you would say that in light of Romer v. Evans and in light of Lawrence, two Supreme Court cases, that courts would be compelled to decide that there is a heightened scrutiny requirement.
Absolutely. I mean, because of Romer, because of Lawrence, because of the long history of discrimination, because of the fact that sexual orientation has nothing to do with the ability of individuals to contribute to society, which make therefore suspect government classifications based on sexual orientation.
Thank you. I yield back.
Thank you, Mr. Nadler. Hope we can be as respectful to the witnesses as we possibly can. Mr. Conyers, I'll recognize you, sir, for 5 minutes.
Thank you very much. Was Mr. Nadler correct when he said your organization raised sums of money against judges in more than one state?
I believe the only judicial election we were involved with was last November's in Iowa, where for the first time in history, the people of Iowa voted down all 3 judges who were up for judicial retention election. Yes, and I'm under oath, so I don't know if it was $600,000 or $650,000, but it was on that order of expense we spent in media informing the voters that these judges had voted for gay marriage, yes.
What about in Maine, your organization in Maine?
We were not involved in judicial retention elections in Maine. We've been politically involved in a number of states.
I'm talking about repealing a law allowing gay and lesbian couples to marry.
Yeah, we were responsible for getting Prop 8 on the ballot, and then we were probably the lead organization in the Maine case.
And is it true that your organization may have spent $1.9 million in that campaign?
I don't have those figures in front of me, but we certainly were involved. That's probably on the order of correct. Again, I didn't really come prepared to testify in detail on those questions, but I'm sure that if that's what you're told, it's on that order.
Well, that's a lot of money.
Well, last year we raised and spent $13 million, to the best of my recollection. So in 3 years, we've grown from zero to that. We have 50,000 donors and about 800,000 people who have
So you plan to raise even more money? It keeps getting larger and larger?
Well, until we win the fight to protect marriage as one man and one woman, we'll try to raise as much money as we can. It'll be a long time till we're as big as the Human Rights Campaign, but that's our goal.
Well, if, as you contend, the will of the people on this issue is so clear, why do you have to raise more and more amounts of money?
Well, do I really have to explain to a congressman that it's important to raise money to get your message out? I think that's the way politics works. One of the reasons I founded the National Organization for Marriage is that I realized that social conservatives, and not everybody who agrees with us would call themselves a social conservative, but that we relied too much on spontaneous mass uprisings of the people. And that, in fact, we needed to be politically organized. And I have to say I learned a lot by watching how effective the gay rights political organizations are about what needed to be done if we're going to have 2 teams on the field in this issue.
Well, I can see why you were invited here. I still am going to consult with the chairman of the committee about the letter that is now contended that we should have invited the Attorney General if we wanted him so bad, but yet we're going to have the Attorney General next month after we've gone through all of this. And Mr. Whelan, you said that this was obviously politically motivated by the president, his conduct in not defending these cases. Are you aware that he campaigned against DOMA even before he was elected president?
I'm aware that he has taken the position as a matter
I
of
said,
policy.
you are aware of that, aren't
As a
you?
matter of policy, yes, not unconstitutional.
All right. And that the issue that we've been really going over here today is not about whether he was going to, whether he's for it or against it. The issue is whether the Department of Justice should defend the case. Isn't that what really the finer issue is about?
Whether the department will abide by its long-standing practice of vigorously defending federal laws for which reasonable defenses may be offered.
Well, what about all of the Bush-era decisions, of which we are told that is several hundred, some have said as high as 750, in which he declared laws were that he was signing were unconstitutional and he wasn't going to enforce them. Has that ever come to your attention as a scholar?
Absolutely, and indeed I addressed that in my testimony. And as I make clear, the source of the president's authority to decline to defend a federal law is exactly the same as the source of his authority to issue constitutional signing statements, a practice that President Obama, over no one's objection, has continued.
I agree with
the
you.
question is whether in any particular instance the exercise of that authority is sound or not.
Well, you mean sound in terms of whether you agree with it or not.
I mean sound in terms of good constitutional judgment, sound and I mean in particular
Well,
here,
look,
I mean
now
sound
the
in terms of the
president,
rationale that the administration
the president,
has offered.
sir, not only is a lawyer, but he taught constitutional law. He was a United States senator, and I'm sure your opinion about what is sound or not is as good as anybody else's, including mine. But why do we have to gather here today to question whether it's sound or not? It's going to be tested in the courts, as you well know.
Well, the fact that President Obama has the strong background that you identify in constitutional law makes it all the more implausible to think that suddenly he's discovered, simply because a case has been filed in the Second Circuit, that his understanding, his long-standing understanding that DOMA was constitutionally permissible but bad policy, was wrong, and indeed that DOMA and marriage laws throughout the country are somehow unconstitutional. It simply isn't plausible that...
What's so implausible about it?
The filing of a case, filing of two cases in the Second Circuit, it triggers this complete 180-degree turn in Barack Obama's understanding of the constitutional status of same-sex marriage. As I document in detail in my testimony, I think one would have to be very naive to think that there's anything other than a stealth strategy of step by step by step, the administration is doing whatever it can to promote same-sex marriage and to induce the courts to adopt that approach.
I am totally confounded by you and I admitting he's a good lawyer, he's a senator, he's a law school scholar, he's taught law, and now you say it's perfectly naive to think that there was anything other than a political motive for him to do what he did.
Let me put it this way.
Wait a minute.
May I respond to that?
Just a moment. Oh, yes, I should let you do that.
You know, the matter would have been quite different if President Obama, when running for president, had said, I believe there's a constitutional right to same-sex marriage. I believe that the Defense of Marriage Act is unconstitutional. It would have been entirely different if, from the outset, the Department of Justice, rather than pretending to defend these cases, had said, we're not going to have anything to do with them, we're following what our president says, we're going to let other people step in and offer an effective defense. Instead, they pretended to defend them, undermining those cases in the process. That whole course of conduct, more than this particular decision in February, is the real scandal.
Mr. Conyers, I think they're going to
Yes.
call a vote here pretty quickly, so I'm going to try it if we can.
Well, thank you for your generosity in the time, Mr. Chairman.
Thank
I
you,
yield back.
And I would now quickly, related to political fundraising, I'm understanding Mr. Obama intends to raise about $1 billion this next time, and if he's convinced that he's got the will of the people, perhaps he should just forego that too. But Mr. Scott, you're recognized for 5 minutes.
Oh, man.
Thank you.
I want to, Mr. Chairman.
He's doing it in the order of attendance.
Mr. Scott?
Thank you, Mr. Chairman.
I gotta go. That's all right. Go ahead.
Mr. Professor Ball, does DOMA prohibit gay marriage in states if states want to do it?
Absolutely not.
Does it deny gay couples the right to have or raise children?
No, it does not.
Does if the bill is on state recognition of gay marriages in other states, if the full faith and credit clause of the Constitution doesn't require it, what is the effect of the law?
If the Constitution doesn't require it, then that part of DOMA, the section, are you referring to Section 2, Mr. Congressman?
The part that prohibits states from recognizing, allows a state not to recognize an out-of-state gay marriage.
Yes. The issue of whether or not marriage recognized in one state is constitutionally that there is a constitutional obligation to recognize that marriage. It's a complicated one, and what exactly the statute adds to that is not entirely clear. But I think
because if it has to recognize that the statute is unconstitutional and meaningless, if it doesn't require it, then it wasn't needed to begin with.
That's correct. There was no. It's part of the problem with DOMA that it was never needed to begin with. Neither Section 2 nor Section 3 were needed.
Mrs. Gallagher, you started to mention something about anti-miscegenation laws. I know Virginia was the case in Loving v. Virginia. We had a law since 1691. 16 other states had laws that were overturned by the Loving case. We've heard a lot about letting the democratic process deal with this. But it was those, I think they're called lifetime activist liberal federal judges violating the will of the people overturned those laws. Was that a good idea to allow those judges to impose their will on the people, or should we have relied on the democratic process to change those laws?
I believe that the constitutional protections for race are extremely important, are properly enforced by the courts. In fact, we took an entire civil war in which 600,000 people died in order to get the Equal Protection Clause, which specifically refers and clearly forbids racial classifications.
So it was a good idea to override the will of the people in that case, but
yes, it was,
and not to allow the judicial process to consider gay marriages.
Well, I have never argued that people don't have a right to litigate. I think that that's a basic civil right. But what I have argued is that the traditional understanding of marriage as the union of husband and wife is not at all akin to interracial marriage and should not be treated by the courts in the same way.
Well, and since 1691, the definition of marriage in Virginia, my home state, was that it could not include blacks and whites.
And we totally agree about that was a good thing to do. What we are disagreeing about is whether there is any analogy to be drawn between interracial marriage and defining marriage as the union of husband and wife, and we probably just substantively disagree about that. I raised it in the context of pointing out, if you really believe that people who think like me and the millions of Americans who think like me, that we're like bigots who opposed interracial marriage, the government is going to intervene very strongly to affect those people's lives in areas from professional licenses, the tax-exempt status of organizations. We're already seeing, in fact, the beginnings of the impact on individuals who belong to traditional faith communities of the idea that these views are akin to racial bigotry.
Well,
we're seeing people losing their job.
Well,
we're seeing licenses threatened. We're seeing people kicked out of graduate school programs. And, I have a serious concern that there are people who really do believe it is like interracial marriage, and that the governments and the courts might
Mrs. Gallagher, remind me what churches were saying about interracial marriages before 1967.
Well, actually, I think I'm a Roman Catholic, so I would argue that the dominant Christian tradition, as practiced not only in the United States but across centuries in history, that there is no grounding for that as a deep Christian idea. But certainly, people made arguments from the Bible on, the devil can quote Scripture for his own purposes. There's no question about that.
Telling me the churches in Virginia.
I'm not. You're stretching my knowledge to go back to the churches in Virginia in the 18th and 19th century. But I certainly, having looked at that, it's quite probable that there were churches who made that argument.
Expired, and I just want to remind people what Professor Ball pointed out, that failure to recognize other states' unions gets you into all kinds of problems with the state tax, real estate, and other things that actually make no sense. And I thank him for bringing that up. I yield back.
Thank you, Mr. Scott, and I now recognize Mr. Quigley for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, you were right. We should treat our witnesses with respect. It's a very passionate issue, and sometimes that makes it difficult for folks to talk. We talk past each other. The law has been talked about a lot here, and it becomes an emotional issue. So I haven't done this yet, but, for me, the issue of how this relates to parenthood has been paramount. So this Sunday, my youngest turns 21, and my kids have been different and different challenges, as every parent can say. And I'd like to think I've been a good parent. Only time will tell. My parents probably felt the same way. So I'm no expert on it, but wouldn't you agree? It's such a personal issue. It's so close. For those who want government to stay out of people's lives, what could be more personal than the decision on who you should love or can love and how to express that love and, raising children? I mean, you've seen the commercials about adoption. They say you don't have to be perfect to be a parent. It has nothing to do with orientation, but you get the flavor of it. I'm not perfect. You talk about as it relates to being able to procreate, stability, that you need a father as well. You recognize that it's probably the minority of straight couples have that kind of situation right now. But we don't tell those folks that they can't be married, or if that's the end of it, they can't. So and I'll let you go out. If it is just a personal thing, and I actually think that hinges a lot of public opinion. I'm no expert, but I think it has more to do with whether or not I was a good parent, or you or anybody else here, more to do with willing to wipe noses, deal with skin knees, teach how to ride a bike, teach how to read, be patient, loving, pretend to know something about girls' fashion. You get the sense of that. I don't think in the moments of being a parent that you're thinking what your orientation is. I sure as heck don't think your kids do either.
We would agree on so much if we weren't in a hotly contested political arena where it's not in anyone's interest to agree.
I just want to be this one time we don't talk past each other.
Yeah, no, I honestly believe 90% of what you said. I believe there are gay people who are wonderful parents. And it's interesting to me that no matter how I try to avoid it, that people interpret what I say as a condemnation of gay people and their parenting skills, because that's not my intent. What I really do believe, however, is that we have an enormous problem in this country. It wasn't caused by gay people, and it can't be cured by them. But it is entirely about how serious we are, not about marriage and as an expression of romantic love, which is doing fine in Hollywood, right? But whether marriage as a social institution is going to fulfill its role of bringing together mothers and fathers and keeping them together in the same loving family for the sake of the children. And I believed as you do, apparently, that same-sex marriage is just going to be about including a few more people in the same institution. What I really do believe is that the founding ideas driving a social institution have big consequences. And the heart of the gay marriage idea is that if you think it's ideal for a child to have a mother and father and that marriage is about this, there's something wrong with you. You're being mean to gay people. That may not be your view, but it is the dominant idea expressed now. If you just go out in the public square and you say, this happened to me in Maine. I was on a radio show, and I said, well, marriage really marriage deserves its unique status because children need a mother and father. And the host turned to me and said, I cannot believe I'm hearing such hatred and bigotry. You know, I understand that some people hear it that way. It saddens me, but it also persuades me that we are in a real fundamental question about what marriage is going to mean.
If your concern is to defend marriage, don't you see greater threats being infidelity, domestic violence, alcoholism, drug use? Those are the things that drive families apart.
I spent about 20 years in the family fragmentation debate working on the issues of divorce and unmarried childbearing, and I still actually devote some of my time to that. But I do see a need. I wouldn't say if I could wave a magic wand and eliminate divorce and have gay marriage, I might wave that magic wand. But that's not the way it works. When you know, just as in the 70s, when I was a child, I was told the no-fault divorce revolution wouldn't affect marriage because it would only affect bad marriages. And I think that turned out to be wrong. I think it affected everyone's marriages by changing the sense that marriage is a permanent commitment. And in the same way, I think same-sex marriage is going to eventually affect everyone's marriage, not mine because I'm old, but by changing the public understanding of what this institution is and what it's for, and by branding people who hold my views of marriage, which again are very powerfully related to its role in protecting children by regulating family structure, by branding people like us as motivated by animus and hatred, and it's going to be hard to sustain that idea if the law adopts that point of view towards the people who hold it.
And thank you, Mr. Chairman. I guess what divides us is that this is a very personal issue, and that you can have your views, but when you do what you do, you limit what others can do to express theirs.
Things that are really, this goes to the oddity of having a personal, intimate decision to invite the government in to regulate your relationship through law. And it is odd in that sense.
Well, thank you, Mr. Quigley. And Ms. Gallagher, I might just say that many of us wish we, in your response to Mr. Quigley, wish we could articulate our position as well as you did. I wish I could say it that well. I'd like to thank our witnesses today for their testimony, each one of them. Without objection, all members will have 5 legislative days to submit to the chair additional written questions for witnesses, which we will forward and ask the witnesses to respond as promptly as they can so that their answers may be included in part of the record and made part of the record. So without objection, all members will have 5 legislative days within which to submit any additional materials for inclusion in the record. And with that, again, I sincerely thank the witnesses, and this hearing is now adjourned.